FishFAQ.
Was your patent application rejected by the Patent Office? You're not alone. It happens to almost all non-provisional utility patent applications. There are several different types of claim rejections. Ineligible subject matter, such as a mere idea or inoperable device. Rejections because the invention is already known. Rejections because the invention is an obvious combination of already known references. And rejections for technical issues, including, for example, indefiniteness and claiming subject matter that was not disclosed when filing the application. There are also objections to the formalities of an application. Objections are usually easier to overcome than rejections by simply fixing the application according to the examiner's suggestions. When filing a response to an office action, the most important thing to understand is that the Patent Office is rejecting the verbatim language of the pending claims, not whatever you consider to be your invention. The correct approach is to view your responses as opportunities to tighten up the language of the claims and negotiate claim scope with the Patent Office. Probably the second most important thing to understand is that the patent examiner is not your enemy. Unlike a litigation, where the other side will oppose your position even if they know they're wrong, patent examiners are just trying to do their job. They're protecting the public against claims that are too broad, and they're perfectly happy to allow claims having proper scope relative to the disclosure and the prior art. After filing your application, you typically get 2 bites at the apple. If the claims are not allowed after you respond to a first office action, the Patent Office typically issues a final rejection, which gives you another chance to respond if the response is filed within 2 months. If still no allowance, you can get 2 more office actions by filing a request for continuing examination, paying an additional fee, and continue amending the claims and arguing with the Patent Office. Rinse and repeat. The process of rejection and response can continue for years. If at some point you find yourself at an impasse where additional amendments and arguments will be fruitless, you can file an appeal with the Patent Trial and Appeal Board, or even District Court, instead of filing an RCE. If you do that, be prepared to spend several years and a lot of money on the appeal. If you have any questions, contact us at fishiplaw.com.
FishFAQ.